If somebody was on your property, is shooting them okay? The debate surrounding this issue has been ongoing since the invention of firearms. The debate is often framed in the context of the United States, where the right to bear arms is a constitutional protection. But on August 9th, 2016, this debate found its way into Canada. Before I begin, I would like to recognize how sensitive of a topic this is. This case involves race, gun rights, use of force, emotions, criticisms of the judicial system, and more. My goal is to make a fact-based video that avoids bias where possible, and where impossible shows both sides. I, as the creator of this video, intend to leave my thoughts out of this video and just focus on the facts. Starting off, what are the facts? Well, on August 9th, Colten Boushie, his girlfriend, and 3 friends went out for a day of swimming and driving, during which alcohol was consumed. Colten lived on Red Pheasant First Nation, and they were driving his girlfriend's gray 2003 Ford Escape SUV, which later had a flat tire. The SUV rolled onto the property of Gerald Stanley, a farmer who lived just outside of Biggar, Saskatchewan, in the RM of Glenside. Gerald and his son, Sheldon Stanley, were repairing a fence, and his wife, Lisa, was mowing the lawn. At first, they didn't think it was anything big, and that it was one of Gerald's customers. He was a part-time mechanic. After they saw one of the occupants, Eric Michance, trying to start an ATV, they hollered at him. After the ATV started, the men ran towards their vehicle. Sheldon smashed the windshield of the SUV with a hammer, and Gerald Stanley grabbed a pistol from his shed. The 2 people who tried to start the vehicle said that Gerald Stanley fired shots at them, whereas Gerald Stanley claims he fired 2 warning shots. The SUV attempted to flee, but collided with Lisa Stanley's vehicle before it came to a stop. Colten Boushie was now in the driver's seat, and at this point, the gun went off and he was killed on the scene. This is where the opinions diverge. Gerald Stanley's defense was that the gun had gone off in a hangfire, and the shot was not on purpose. Belinda Jackson, who was in the back seat, claims she saw Stanley shoot Colten 2 times intentionally. There were multiple problems with the investigation immediately after the incident. For one, no blood spatter expert attended the scene, and by the time a forensics team showed up on August 11th, the footprints and blood were washed away by the rain. All 3 of the Stanleys and everyone else in the car were taken into custody, but everyone except for Gerald Stanley was released. Stanley was granted bail and released within a week. The night of the incident, RCMP informed Colten Boushie's family of his killing. Later, a loaded rifle that didn't belong to Gerald Stanley was found in the car, suggesting they might have threatened the Stanleys as well. In the media, there were many questions about what happened. Would Gerald Stanley have reacted differently if these were white young adults and not Indigenous kids? Or was Gerald Stanley just a family man who was concerned for his family? This started a conversation about racial relations with Indigenous people and gun rights in Canada. In Canada, there aren't legal protections for using a gun in self-defense. As evidenced by the verdict, there is some evidence that a legal precedent exists for cases like this. Was Gerald Stanley lying about a gun just going off? Even if he was lying, was he in the right? It's arguable that 5 people who had been drinking all day walking onto your property and hopping on your ATV is going to be concerning. Also, from a legal perspective, why were Gerald Stanley's guns so accessible? Legally, guns must be stored securely and locked up, and ammunition must be stored separately from the guns. Many would say that the chances of this being the case in a Saskatchewan farmer's shed seem unlikely. Also, this called into mind the fact that for Gerald Stanley, it's not like the RCMP would have been there in minutes.
But people who live out here say that's because they're not calling police anymore due to slow response times.
No, it would have taken them much longer to get to his yard, possibly over half an hour. Gerald Stanley was charged with second-degree murder and a lesser charge of manslaughter, and the trial began on January 30th, 2018. The trial got off to a quite controversial start, as all of the jurors appeared to be white, and all of the visibly First Nations jurors who were summoned were challenged by the defense. The defense argued that there was no reason Mr. Stanley had intentionally killed Colten Boushie, and they told the jurors to put themselves in the defendant's position on the day and talked about the hangfire defense. The prosecution argued that Gerald Stanley had a motive to murder and that the incident would have had a different outcome had the people been white and not Indigenous. Both sides poked holes in each other's stories. There was no real evidence to disprove a hangfire. They just had to prove that he had the intent to kill and that the use of force was unnecessary. However, Belinda Jackson's previously credible claim about 2 shots somewhat fell apart in the autopsy when they only found 1 bullet hole at the back of the head. The defense was also questioned about the credibility of the accomplices to Boushie. They brought up the criminal records of each of them. One of the accomplices also testified to using the rifle to attempt to break into another farm earlier that day. Throughout the entire trial, Gerald Stanley was quite careful to not officially plead self-defense or allude to it, as this would be seen as an admission that the hangfire defense was a lie and would turn the trial into a case of whether the use of force was appropriate, which would be a very different trial. In Canada, like most places, there is an assumption of innocence until proven guilty beyond unreasonable doubt, which was stressed by the judge. On February 9, 2018, a verdict was reached. After 15 hours of deliberation, Gerald Stanley was found not guilty of second-degree murder and of manslaughter and acquitted. The verdict surprised many, as many expected a conviction on at least the count of manslaughter. This verdict was just as divisive as the trial, with many, especially those in Indigenous communities, frustrated by the verdict and viewed it as an embodiment of broader systemic racism and institutional issues.
A white jury came out with a verdict of not guilty of Gerald Stanley, who shot and killed my nephew.
Both Prime Minister Trudeau and Justice Minister Jody Wilson-Raybould made comments about needing to do better, interpreted as criticism of the verdict. They were joined by the NDP, who more outright opposed the verdict. The Conservatives' line was that they had to respect the jury's decision, but individual members did freely talk about broader issues raised by the case. In March 2021, the Civilian Review and Complaints Commission concluded a 3-year investigation into the RCMP's handling of the Colten Boushie case. The report revealed insensitivity and racial discrimination towards Boushie's mother. She was, some would say, basically treated like a criminal when she was told of Colten Boushie's death, and asked if she had been drinking, and when they said that they had dinner ready, they walked into the house to see if this was true, etc. There were also some mishandling of evidence and witnesses, most notably the car being left outside in the rain and a problematic initial press release. While the police investigation was deemed generally professional, the report highlighted a need for meaningful organizational change. The RCMP's parallel internal probe, revealed later, raised concerns as records were allegedly destroyed without notifying the watchdog. A consequence of this case was negative reactions and sentiments towards Indigenous peoples, as there were comments on social media that were objectively racist, many calling for violence towards Indigenous peoples in Canada. The abolition of peremptory challenges, or challenging a juror's ability to serve without reason, though that was challenged for potentially conflicting with the accused's rights. Increased Indigenous distrust in the Canadian judicial system, and revelations of systemic racism in law enforcement. A post-acquittal poll reflected divided public opinions, with 32% of Canadians viewing the verdict as wrong and 30% as fair, reaching 63% in Saskatchewan, where the events took place. But what are your thoughts on this case? Leave them in the comments. I hope you guys enjoyed this video. If you did, please consider leaving a like and subscribing, as it helps me out a lot. But apart from that, have a good rest of your day, and see you.